Now, the last division of law. The last division of law I will explain to you today is private and public law. First of all, I will explain what is public law before going into the private law. Public law is the branch of law that deals with the relationship between the state and the individuals. It is a legislative enactment affecting the public at large. The state strictly apply rules under public law on the citizens and do not allow any breach of these rules, as lawlessness will end up existing in the society. The state imposes punishment to those who would have infringed the public law. Public law is further split into administrative, constitutional, and criminal law. Let us look at the categories of public law in detail. Administrative laws are those laws that govern the formation and operation of administrative agencies and the rulings made by administrative agencies. Agencies mentioned here may include those concerned with the road traffic laws, labor acts, national water distribution, and land. These are the agencies we are talking about. This will help you to picture the administrative law and the administrative agencies we are talking about. The laws under administrative law governs formation and operation of administrative agencies of a state, as we have said before. The administrative law determines the organization's powers and duties of that administrative. Usually, the administrative law deals with the day-to-day administration of the state. This type of law is sometimes called the regulatory law. These agencies administer laws and manage public programs through the use of rules and regulations. Most administrative agencies are created in order to protect a public interest, such as privacy, civil rights, or disease prevention. Each agency is responsible for administering a particular set of laws, or often a particular legislative act. A legislative act contains a set of laws. Agencies often possess the power to grant licenses and permits, investigate complaints, and punish infractions, as well as many other duties related to a particular set of laws. The examples we have are Water Rights, Labor Acts, Road Traffic Acts, Patients Acts, and Shop License Acts. Maybe you are wondering, where do admin laws come from? The process starts with the legislature passing an act, which then becomes a law. The law then goes under the organization or agent, which is responsible for ensuring that the terms of that law are complied with. Next, constitutional law. Constitutional law is a body of law which defines the role, powers, and structure of different entities within a state. It regulates the distribution of government functions and the manner in which these functions are exercised. Constitutional law governs the relationship between state authorities to each other and to the individual citizens. A government has its powers defined by the Constitution. The Constitution is made up of a set of rules which set up the framework of that state. Under constitutional law, government powers are divided into three separate branches, namely the executive. The executive puts all the laws into action and executes orders and sentences of the judiciary. The legislature. The legislature is made up of people or a body of persons who make laws. Then the judiciary. The judiciary make up our courts. It decides on disputes in accordance with the laws and also handles the application of criminal law and the sanctions imposed on people. The criminal law. It is the law relating to crimes. It is the body of laws that defines criminal offenses regulates the apprehension, charging, and trial of suspected persons, and fixes penalties and punishments to convicted offenders. Most criminal law is established by statute, which is to say that the laws are enacted by a legislature. Criminal acts can be punished by fine, imprisonment, community service, or death penalty in extreme cases. The essential factors that should be present if an act is to be criminal are: the wrongdoer must have failed to act in accordance to his legal duty. Everyone should be a good citizen. So a wrongdoer fails to act in accordance to his legal duty. If he commits a crime, for example murder, the wrongdoer must be involved in some kind of action which is illegal. Because a man cannot be punished for his thoughts alone without some positive act on his part, he cannot be said even to have attempted to commit a crime without the act. So the wrongdoer should do something that is considered as a crime. So the wrongdoer must have failed to act in according to his legal duty. The wrongful act must be voluntary. A wrong done by a sleepwalker or a person having some fits would not be voluntary, so won't be punishable. So the act should be voluntary. The person should do it knowingly and willingly. For example, a thief. That was all I had for you on public law. Let us now move on to private law. Private law is the law that deals with the relations between individuals or institutions rather than relations between these and the state. It deals with the relationships between two private individuals in that state. In private law, the state takes no direct interest in protecting rights. The state just provides the people with the court machinery, and it is left for individual citizens to enforce their rights. For instance, if James were to breach terms of the contract he has with Leo, the state is not concerned at all. Leo is the one who should approach the courts and ask for damages he incurred due to that breach. Private law have 5 subclasses in which it is analyzed and discussed. The subclasses are law of delict, law of persons, law of trust, law of contract, and law of property. Law of delict is a civil wrong consisting of an intentional or negligent breach of duty of care that inflicts loss or harm and which triggers legal liability for the wrongdoer. The law of delict acts as a regulator of social conduct by establishing how people should behave in relation to one another, as it lays down when one person is delictually liable to another. The wrongdoer who causes harm is made to pay compensation to the wronged person. For instance, defamation in Zimbabwe, driving under the influence, accident occur, the offender pays for all medical expenses and repairs for the cars which have been involved in that accident. Injury caused by a person or thing under his custody. For example, if a dog attacks someone, the owner of that dog have to pay for medical expenses and all the damage done by the dog. Next, the law of persons. The law of persons governs the determination of legal personality, what beings are legal subjects, and the effects of various factors on a legal subject. Artificial persons are entities who can acquire rights, become subject to duties, can sue and be sued. For example, companies. Law of persons include the following: various classes of persons who have limited legal capacity, for example, minors. Rules which determine how a legal person comes into being, how he ceases to exist, the distinctions which divides legal persons into different classes, and the legal status of various classes. Also includes family law, which refers to law of domestic relations. This section deals with the formation, dissolution, and suspension of marriage and the legal consequences of each. Next, the law of trust. A trust is an arrangement that allows a third party or a trustee to hold assets on behalf of a beneficiary or beneficiaries. Trust can be arranged in many ways and can specify exactly how and when the assets pass to the beneficiaries. Any form of a trust is created and registered by a registered notary public in Zimbabwe. The trust is only valid if it bears the notarial stamp or notarial seal of duty registered. Notary public and the same deed shall be registered with the deeds of registry in Harare or Bulawayo. That was an example for those in Zimbabwe. The major classes of trust are revocable trust. This is a trust also known as a living trust. It is used to avoid having the estate subject to the official proving of a will or the legal processes of distributing your estate. So that is a revocable trust. Then, irrevocable trusts. Contrary to revocable trust, assets in an irrevocable trust can be removed or amended after they have been placed in the trust. Since you have relinquished control of assets placed in an irrevocable trust, they are effectively removed from your estate, thereby protecting you from possible estate taxes. Testamentary trust is the last class I have for you. So rather than creating and funding a trust immediately, it's possible to create a trust that goes into effect upon death. The trust that goes in effect upon death is the testamentary trust. This type of trust is created through a will, and the terms of the trust are spelled out within the will. Testamentary trusts are often used as a tool that can help one create a trust for minor children. Next, the law of property. Property law is the area of law that governs the various forms of ownership in real property and personal property. Property refers to legally protected claims to resources, such as land and personal property, including intellectual property. Property law deals with the allocation, use, and transfer of wealth. It governs the various forms of ownership in real property and in personal property. Next, the law of contract. A contract is an agreement between two or more persons which gives rise to personal rights and corresponding obligations. So, law of contract governs the lawful agreement made by two or more persons. Maybe you are wondering what makes a contract lawful. For a contract to be lawful or valid, it should have the following essential elements. The parties must communicate their intention to each other. Parties must tell each other somehow their intention to enter into the contract. This is done through an offer which is accepted by the other party and the two enter into a contract. Parties should have full legal capacity to contract. For instance, minors, insane, and drunkards have limited capacity, so one should enter into a contract with a person who is considered to have a full legal capacity to contract. Agreements must be lawful. The contract should be an agreement to do or perform lawful things. Illegal things do not make up a contract. It will be a crime. For example, contract to murder someone or to move illegal drugs from one place to the other, that is drug trafficking. These are not contracts but crimes. Agreement must not be vague. Contract terms should be clear to all parties and easy to understand. Agreement must be one for performance and non-performance in the future. Performance of the contract should be in the future. You can't have a contract to do something 5 years ago, that is in 2015. It's impossible. But if the contract is for 2025, the contract is sensible, as the things or terms of the contract will be performed in 2025. Contracts must be executed or put into writing. This is for evidence and showing truly that the parties are bound by the contract terms. It is evident that the people are bound by the contract terms through signatures. Imagine if hire purchase or credit sales were not signed, parties would change figures for their benefits. Fraud would be at its peak or maximum. So writing down a contract is very essential. If you want more information on this, visit Law of Contract lesson number 1. The lesson is on the definition of contract and the essentials of a valid contract. The examples where law of contract is in use are the law of purchase and sale, the law of employment, the law of insurance, the law of agents, law of lease and partnership law. That was all I had for you. Now let me list exam questions relating to this lesson which are frequently asked. Classify law into divisions. Write brief notes on the functions of the following arms of the government: the executive, the judiciary, the legislature. Write brief notes on constitutional law. Thank you so much for watching. If you have benefited a lot from this lesson, subscribe to this channel so that you won't miss out on more videos I post regularly. Like and comment below if you have any suggestions and questions.